I feel that it would be imprudent to provide my advisory views with regard to that issue.
Look, I agree with you, Judge. I'm not asking your advisory view. I'm asking you to tell me what the law is.
And the Supreme Court said, actually, plaintiffs have a strong likelihood of success on the merits. You said they have no likelihood of success on the merits. So just help me explain. The Supreme Court took a totally different view. Help me explain how you looked at the same Constitution and came to a totally different conclusion. Why is it okay to single out religious people for disfavor? I don't understand it. This regulation wasn't neutral and generally applicable. It had one set of rules for shops, businesses, and a completely different set of rules for churches, which is, of course, what the U.S. Supreme Court ruled. I don't understand how you can look at that and say it's neutral and generally applicable.
What's up, everyone? Welcome back to the channel. Today, we're diving into a fiery Senate hearing where judges were grilled on constitutional rights, agency power, race, and religious freedom during the pandemic. The questions were sharp, the answers were cautious, and the stakes were high. Stick with me, because this one gets heated. And before we get started, make sure you smash that subscribe button so you never miss breakdowns like this. I start with Judge Lee, who faced tough questions from Senator Kennedy about the Chevron Doctrine. That's the rule where courts are supposed to defer to agencies on matters Congress entrusted them with. But here's the kicker. When Kennedy asked him to explain how much deference courts should actually give, Judge Lee refused to pin down an answer. He kept saying the issue was hotly contested and wouldn't commit. Kennedy pushed harder, asking for the current state of the law, not opinions. Still, the judge dodged. The exchange showed just how controversial Chevron has become and how reluctant nominees are to lock themselves into a position.
Judge, congratulations. I'm not going to ask you your opinion on precedent, and I'm not going to really ask you about past cases. I just want to talk to you a little bit. Judge Lee, tell me what your understanding is currently of the Chevron Doctrine.
Thank you, Senator Kennedy, for that question. My understanding currently of the Chevron Doctrine is that the doctrine is a general matter that courts should give deference to agency factual determinations to the extent that the agency has been empowered by Congress to regulate certain areas.
How much deference have the appellate court said you should give? Explain what you mean by giving them. I know what deference is, but do you give them a lot of deference? What if they come up with an interpretation that is patently absurd? Do you have to defer to that?
Thank you, Senator Kennedy. Senator Kennedy, I know that the issue of the Chevron Doctrine and the deference that courts should afford to agencies is an issue that is currently hotly contested in various litigation. And as a sitting district judge and as a nominee for the Seventh Circuit, I feel that it would be imprudent to provide my advisory views with regard to that issue.
Look, I agree with you, Judge. I'm not asking your advisory view. I'm asking you to tell me what the law is. What's the current state of the law? I agree with you. Under Chevron, the courts have said Congress has delegated this expertise to the regulatory agencies. You're supposed to defer to them. What is the current state about how much deference and when, if ever, you don't defer to them? That's all I'm asking.
Again, Senator Kennedy, given how hotly contested that issue is, I feel that at this point in time, as a sitting district judge and as a nominee to the Seventh Circuit, that...
Judge, let me interrupt you. You're telling me you can't tell me what the state of... You won't tell me what the state of the law is on the Chevron Doctrine? I'm not asking your opinion on it. I'm just telling me, what's the latest guidance? Let me rephrase it. What is the latest guidance that the United States Supreme Court has given us on the Chevron Doctrine? I mean, it's pretty important stuff.
Yes, Senator. The Chevron Doctrine, as I stated, was that the court should give deference to agency determinations in matters that specifically deal with their particular realm that Congress has delegated.
We went over that. How much deference? When do you not defer to the agencies?
As I recall, Senator, the degree of deference that a court should afford agencies really deals with the process that the agency went through in making its determination, as well as to the exact and precise nature of that determination.
Yeah, I don't agree with that, Judge, but that's okay. I'm surprised you haven't seen the issue of Chevron before. You're going to see it on the Court of Appeals. It's pretty important stuff. Let me ask you, Judge Mendoza, one question. I've only got a little bit of time left. Look, you wrote a law review article back in law school, and I don't hold that against you. You know, when I was in law school, we all did things when we were young that, you know, it seemed like a good idea at the time, okay? But you made, if I got this wrong, tell me. But you made one statement. I was looking at your piece. I think this came from your article. I'm gonna read you the quote, and I just didn't understand it. Here's your quote. One must understand race as a socially constructed phenomenon that has historically served to subordinate racial minority groups while maintaining white supremacy. I've never thought of race as a socially constructed phenomenon. Tell me what you meant by that statement.
Thank you, Senator, for that question. And I think you're referring to that article that I wrote 26 years ago, when I was a law student. And of course, since that time, Senator, I've became an attorney. I swore an oath. At that point, I became a judge.
No, I'm not trying to trip you up. I'm just trying to understand what you meant by it. When I first read it, I said, well, you know, that's an interesting construct. I just don't understand it.
And Senator, as I sit here now, I can't recall that specific quote, but what I can tell you is when I deal with the issue of race in my court, it's usually in a claim. And what I do in those claims is I apply the precedent on the matter. I look at the facts and I make those determinations and base my decision only on those issues and nothing else.
Okay. Thank you, gentlemen. Congratulations.
Judge Lee, let me start with you. You are committed to the Constitution, I assume. Is that fair to say?
That is fair, Senator.
And to the Bill of Rights?
Yes.
And do you think the Bill of Rights is deeply important to our foundation of government? Is that fair to say?
I do.
And the Equal Protection Clause as well. Is that fair to say?
Yes, Senator.
And the Constitution doesn't contain an emergency powers exception, does it? An emergency exception? Can it be suspended in the case of an emergency?
There is nothing explicitly in the Constitution that provides any sort of suspension during cases of emergency.
Can the Bill of Rights be suspended during an emergency?
There's nothing in the Constitution that provides for that.
What about the Equal Protection Clause? Can it be suspended during an emergency? Government disfavor a certain group of people because it's convenient for the government?
Again, Senator, there's nothing in the Constitution that provides for that.
Okay, help me then understand your opinion in the Cassell case. This is about Governor Pritzker in your state, his orders, or within your jurisdiction, his stay-at-home order during the COVID-19 pandemic. He issued an order that allowed essential businesses and operations to operate at 50% capacity, but it applied only to secular institutions and services. He explicitly said religious activity was subject to a different rule. Religious activity, churches, synagogues, could only have 10 people in them. Everybody else, all other essential services could have 50%, so hundreds of people, go shopping, whatever. But religious activity, only 10 people or fewer for those folks. Different rule, explicitly different rule. You upheld that in the Cassell case, this differing standard that singled out religious people for disfavor. And you said that the Supreme Court of the United States has said that different rules apply during pandemics. The strange thing is I'm reading the case on which you relied, and it says nothing of the sort. You cite Jacobson versus Commonwealth of Massachusetts. That's a 1905 case. You say that the Jacobson court explained that the traditional tiers of constitutional scrutiny do not apply. That phrase doesn't appear anywhere in that opinion. Tiers of scrutiny weren't invented by the Supreme Court for another 40 years. So help me understand where you're coming from in this case. Why did you conclude that religious people could be singled out for disfavor?
Thank you, Senator Hawley, for that question. As I stated previously, when I decided the Cassell case, which was later affirmed by the Seventh Circuit, it was early on in the pandemic, and we did not have the benefit of the various other rulings by the Supreme Court that came down after my ruling on Cassell.
That held just the opposite.
That I guess I'm referring to Roman Catholic as well as Handon.
Right,
and,
in which the Supreme Court held that you could not single out religious people for disfavor. State of New York tried to do precisely the same thing. And the Supreme Court said, actually, plaintiffs have a strong likelihood of success on the merits. You said they have no likelihood of success on the merits. So just help me explain. The Supreme Court took a totally different view. Help me explain how you looked at the same Constitution and came to a totally different conclusion. Why is it okay to single out religious people for disfavor? I don't understand it.
What I looked at was whether or not the Governor Pritzker's order was neutral and generally applicable, to decide whether, at that time, secular activities were generally applicable. I looked at the type of activities as well as kind of the sort of risks, the varying degree of risks that were present in those instances. So, for example,
well, can I just stop you right there? I'm sorry, I've only got 1 minute left. I'm sorry, but you've raised, I think, a really important point, because the standard is, when it comes to First Amendment violations, is the law neutral and generally applicable? This regulation wasn't neutral and generally applicable. It had one set of rules for shops, businesses, and a completely different set of rules for churches, which is, of course, what the U.S. Supreme Court ruled. I don't understand how you can look at that and say it's neutral and generally applicable.
The order, as I recall, also closed, for example, movie houses and auditoriums, as well as schools. And so when I considered the activities at movie houses and schools compared to activities carried on at churches, I found those to be, at the time, using the time pre-Tandon test, to be generally comparable or comparable. I agree, and I found that
But the order said that religious houses of worship were essential. So it said that essential businesses could be open, essential services, but at 50%. Initially, it didn't include any carve-out for religious, any acknowledgement that religious services might be essential. He amended that, said, no, they are essential, but I'm going to cap them. So two completely different rules. Let me just, my time's about expired, so let me just read to you something from the Jacobson case, which you cite, which I'm surprised you didn't heed. Here's what the Jacobson case says. No rule prescribed by a state, nor any regulation adopted by a local governmental agency shall contravene the Constitution of the United States or infringe any right granted or secured by that instrument. A local enactment or regulation, even if it's based on the police powers of a state, must always yield, in a case of conflict with the exercise by the government of any power it possesses under the Constitution, or to any right which that instrument, meaning the Constitution, gives or secures. I'm baffled that you would cite this case in support of a decision that treated religious believers differently, indeed disfavored them, compared to other people. And I think the fact that the Supreme Court reversed on precisely this case later doesn't say much for the analysis that you employed, which frankly I find pretty alarming.
Next, Judge Mendoza came under fire for an old law school article. In it, he wrote that race is a socially constructed phenomenon used to uphold white supremacy. When pressed, he distanced himself from the article, saying it was written over 25 years ago as a student. Mendoza stressed that as a judge, he applies precedent, looks at the facts, and rules strictly on the law. Kennedy accepted the answer, but clearly wanted to highlight how past writings can resurface in confirmation hearings. Then came a critical constitutional moment. Judge Lee confirmed there is no emergency powers exception in the Constitution. No provision allows the Bill of Rights or Equal Protection Clause to be suspended just because the government finds it convenient during a crisis. That statement set the stage for a much deeper confrontation. Senator Hawley zeroed in on Judge Lee's ruling in the Cassell case during COVID-19. Governor Pritzker's order capped religious gatherings at 10 people, while businesses operated at 50% capacity. Lee upheld that rule, citing Jacobson v. Massachusetts from 1905. but Hawley was relentless. He pointed out that the Supreme Court later ruled the opposite, siding with religious groups in cases like Roman Catholic Diocese v. Cuomo. Hawley argued Lee misread Jacobson, especially since it explicitly says no state regulation can override the Constitution. He was baffled that Lee treated religious believers differently and called the analysis alarming. This entire exchange highlights something massive: how judges interpret the balance between government power and constitutional rights, especially in emergencies. It also shows how the Supreme Court has been steering more firmly toward protecting religious liberty, while lower courts like Lee's earlier ruling lean toward broader government authority. These differences in interpretation could have huge implications for future cases on freedom, agency power, and emergency governance. So here's the bottom line. Senators pressed these nominees on some of the most critical constitutional questions of our time. Chevron Doctrine, old writings on race, emergency powers, and religious freedom, they all collided in one explosive hearing. And as we saw, the answers judges give now, or avoid giving, could shape how America balances freedom and authority for decades to come. If you found this breakdown helpful, hit that like button, drop a comment with your thoughts on the hearing, and don't forget to subscribe for more hard-hitting political and legal analysis. Thanks for watching, and I'll see you in the next one.